SJC-11415, William Adair and others v. Personnel Administrator of the Commonwealth and others.
Let's proceed. Good morning.
Good morning, Your Honors. Joseph Delory for the appellants. May it please the court. I hadn't anticipated opening my presentation to the court in a manner that I'm going to, but in preparing for presentation of this case over the last week or so, I viewed a position or discovered a position within my argument that is difficult for me to overcome. I had crafted my argument based upon a presumption that I have to acknowledge is in error. We have based our argument on behalf of the union and the employees who are the individual plaintiffs under the assumption that they enjoyed protection or the benefit of Chapter 30, Section 46, subsection 5, which deals with what happens when the employer uses what's known as a recruitment rate, bringing somebody in from the street at a rate higher than the initial step. The statute says if the employer does that in order to attract somebody in, because that's the market rate value of the work, that the people who are currently on the payroll should be brought up to that rate because that's the value of the job in the marketplace. The collective bargaining agreement that was negotiated for the plaintiffs and for the rest of the members of the union allows the employer to bring somebody in at a higher rate, but is silent as to what happens to everybody else.
Right.
When the named plaintiffs and others had new members and new employees come in as their colleagues at a rate higher than their rate, they were upset, turned to us, and we saw the statutory language that mandates the personnel administrator must advance everyone else on the salary schedule to the rate of the value of the work in the marketplace as defined by the highest step for the new employee. We couldn't seek relief under the collective bargaining agreement because the contract is silent as to what happens to everybody else, so we sought relief under the declaratory judgment statute. Commonwealth filed a motion to dismiss. We argued before the lower court. The court's decision is before you, of course. And I was prepared to attack the logic that the court used in reaching its conclusion. But this is a de novo review with statutory interpretation. My sister raised an argument that I must stand before you and acknowledge is correct. And I think it's a fundamental shortcoming resultant in my case.
Does that resolve this dispute?
Well, I can't see a way around it, Your Honor, to be perfectly candid, and I hadn't anticipated appearing before this court and having to say that, but I can't otherwise state. Here's the problem in a nutshell. Chapter 30, Section 45 and Chapter 30, Section 46 constitute the pay and classification plan of the Commonwealth. Within Section 45 and subsection 9, there's a definition of certain terms. The term employee is defined. It is defined as someone who's an employee of the Commonwealth, the plaintiffs, in a non-managerial position, the plaintiffs, allocated to the general salary schedule. Sorry. The salary schedule that the plaintiffs and the other members of the union are paid under, of course, is the negotiated salary schedule in the contract appearing as pages 45 through 47 of the appendix to our brief.
And it's also explicit that the salary schedule that's in Section 5
46 is where the general salary schedule
does not apply to people who are members of a union.
And we're making our argument because the lower court had said the Section 46 begins with the salary schedule, grades and steps. They don't cover our members. Our members negotiate their salary. The next sentence is, the above salary schedule shall not apply to employees represented by a union, the so-called limiting language that I talk about in my brief. My argument is, if it's put in subsection 1 of Section 46, it doesn't undo our members having access to the relief in subsection 5 of Section 46. Hence, they should be advanced when a new worker shows up at a higher rate of pay. if the statute was read in a vacuum, it's a simple declarative, unambiguous sentence. I missed the import of the definition of employee in Section 45. In my brief before submitted to this court, on page 15, I made a simple declarative sentence that the members are non-managerial employees and assigned to the general salary schedule. I don't know, I cannot defend that position. My sister, in her brief in footnote 5, pointed out that before the Superior Court, I correctly stated the members are governed by the negotiated salary schedule. I can't have it both ways. I was right before the Superior Court. I can't articulate for the court why it reads what it reads, but it does. My position before the Superior Court that they're governed by the negotiated salary schedule is true. And while I could argue with the logic that the lower court engaged in to reach a decision against us in footnote 4, of the extensive footnote that's referenced in my brief, I can't see a way around the definition of employee appearing in subsection 9 of section 46.
And that's because
My members are not allocated to the general
allocated to
salary
general
schedule.
salary schedule, so therefore they're not defined as employees within the meaning of section 45.
I hadn't anticipated this would be my argument, but as I was sharpening my pencil over the weekend and over the next intervening days, I ended up calling a couple of colleagues saying, do you see a way around this? Because I think they're right. And that's why I'm standing in front of you saying what's in the blue book is wrong, what's in the red book is right. There's a class of people that are entitled to the relief under section 46(5). I can't stand before you and defend a decision on your part that these plaintiffs are among that group of people.
Is another way, is a corollary to that, that union members negotiate the terms of a collective bargaining agreement? That's the whole purpose of collective bargaining agreements, is to set their salary schedules regardless of what else exists.
And the problem was, Your Honor, that the only thing in the contract, or in any of the state contracts, this happens to cover the 10,000 or so blue-collar, direct care worker, non-professional group. The contract says the employer can use the rate of bringing somebody in other than step 1 if need be. Mm-hmm. But it's silent as to what happens to everybody else. So the lower court dealt with the issue of Chapter 150, Section 7D. There's a list of statutes. If there's a conflict between the statute and the contract prevails. Well, there's no conflict if there's silence. So my argument was unambiguous language, simple declarative sentence within subsection 5. Condition precedent, somebody brought in at a higher step, bring everybody up. Mm-hmm. My problem as I came down the stretch sharpening my pencil for this argument was the definition of employee in 45(9). Somebody allocated to the general salary schedule. My members aren't. So I could spend time attacking the judge's algebraic analysis and the extensive footnote. I can't see that's going to get me anywhere different. I could speak to the mandamus, I could speak to the class action, but I wanted to lay the cards on the table at the outset. This is a problem with my case, and I
appreciate your candor.
Appreciate your candor.
Yeah.
I've never had that happen before.
Me either.
Thank you very much.
Thanks. I just ask you, this has nothing to do with the case, but as a practical matter, okay, your clients are employees, members of a union. When there are people who have been employed at higher step rates in comparable jobs, or the same job, same class of job, does that come up in the next bargaining round?
It's going to, Your Honor. Here's the problem. Up until, well, today or soon hereafter, I have to anticipate, I considered this a statutory benefit that through practice and inattention or whatever, no one had articulated a right. Why would I put it on the bargaining table if I had it by virtue of statute? If I try to negotiate this benefit for the members, I see the representative of the employer sitting in the back of the room, I anticipate they may look for a concession. If I have it by virtue of statute, I don't have to give up 2 sick days.
Right.
We're commencing negotiations relatively soon. I have a feeling this is going to come up. But I needed, in effect, a declaratory judgment because I didn't want to take the employer's word for it that I don't have it. And as I said, in preparing for today, I found a hole in the boat.
So where are we? Will you file a motion to dismiss the appeal?
Well, I hadn't finally crystallized this until really yesterday, Your Honor, and I reached out to my sister and we talked about that. My problem was when dawn finally broke, I have 2 types of plaintiffs. The union, seeking all of its members similarly situated, I could go to my executive director, he had authorized me to withdraw the case and dismiss. I have a half a dozen individual plaintiffs. I didn't want to call them last night and say, hey, you know that case before the Supreme Judicial Court? That's a conversation I want to have face-to-face with them. But I anticipate at the end of the day, Your Honor, I would intend to approach the other side and say, do we want to investigate that as an option?
You want a little time.
So we should hold off on,
Yeah,
on
doing anything.
doing anything.
I
Then you report back to us?
I would hope so. I can't speak for my sister, but that would be, I think, in the interest of justice and practicality.
All right, thank you very much, sir.
Thank you, counsel.
You're welcome. Thank you, Your Honors.
Do we need to hear from you?
You can tell us that you're wrong and he's right?
No, I won't say that. No, I won't take the court's time this morning in light of my brother's argument. I would, though, like to emphasize that we are asking for an affirmance on the grounds advanced in our brief. And just to very briefly highlight 2 points, the Commonwealth versus the Labor Relations case, which is cited.
Wait, let me just ask you this. Are you saying that if the plaintiffs seek to withdraw the appeal, you're going to disagree with that?
No, I'm not, Your Honor. And we had discussed yesterday a Rule 29 voluntary dismissal. They weren't prepared yesterday to do that, so we are going forward today. I do not anticipate any objection if that motion is filed prior to the issuance of a decision.
So we wouldn't be affirming on the basis of the, it seems to me we wouldn't be doing anything if that's the case, right?
It's my understanding the court did not wish to hold this case over until my brother was able to canvass all of his plaintiffs, and that he wished to go forward this morning and hear argument. I guess in the event, as unlikely as it sounds, that a motion for dismissal is not forthcoming. And so I just, in respect of that, I wanted to present our argument so that if you found yourself in a situation where the motion did not appear, you had heard from us. And I don't want to take, certainly don't need all of my time. We do rely on the grounds in our brief. And just really quickly, I would just cite and emphasize the labor relations case cited in my brief and the import of reading Chapter 30, Section 46 in harmony with Chapter 150E, Section 6, which has to do with wages.
Thank you very much, counsel.
Thank you very much.
Thank you both.
Thank you.